Chapter 6, we're going to talk about the different types of witnesses. There's 5 key issues when we think about the competency of a witness, whether or not the witness is competent to testify, how the credibility of the witness could be attacked or how it could be bolstered, what can be done if the witness's memory is faulty, testify about. So a competent witness has a duty to tell the truth. This means that their testimony has to be given under oath or affirmation. False testimony is punishable by perjury. And we also have problems arise with testimony by children or testimony by people who are mentally ill. So a lot of times a judge will have a hearing or sit and meet with the potential child witness ahead of time, basically to determine if they know the difference between a truth and a lie. Competent witnesses have a duty to narrate the events. They need to be physically able to speak and recall events and able to speak English or have a proper translation. There's a procedure to establish whether or not someone is competent to testify, and it's usually done before testimony in a process called voir dire. And yes, the jury process is also called voir dire. Voir dire means to speak the truth. One thing we try to do during, that the opposing side is going to try to do during testimony is to impeach the witness. This is defined as attacking the credibility of a witness. It's typically done during cross-examination and can also be done by calling another witness who testifies differently. There's 6 main ways we can impeach somebody: through bias or prejudice, previous felony convictions, immoral act or uncharged crime, prior inconsistent statement, inability to observe, and poor reputation. Bias or prejudice. When we impeach somebody this way, we're showing that they have a motivation based on profit or emotion, or we're showing that there's a relationship, racial, or financial motive for their testimony. Traditionally, felons have been barred from testifying, but today the prior felony conviction is used to attack their credibility. Under Federal Rule of Evidence 609, we can impeach somebody for a past offense. Generally, only felonies may be raised, and the past crime should be related to honesty or making false statements. Because again, you're trying to attack them saying that their testimony is false, and therefore you want those past crimes to be related to or demonstrative of their inability to tell the truth, or a predisposition to not tell the truth. You can impeach by immoral act or uncharged crime, and those should also be acts related to truthfulness. You can point to prior inconsistent statements. A past statement doesn't have to completely contradict the current testimony. You have to prove that the past statement was made. Anything that is non-Miranda statements can be admissible, mostly because you're using them to impeach here. We could impeach somebody by saying they were not able to observe what they claim to have observed. This could be because they were distracted, the location, or some type of physical handicap. Reputation. These types of attacks are usually restricted, again, to the trait of honesty. Once your witness has been impeached, you are going to try to rehabilitate that witness. That's an attempt to restore their credibility once they've been impeached, and it is usually done during redirect. That's done by showing that they have current good behavior, by offering explanations about the prior inconsistencies, showing that they weren't impaired, they were able to properly see something, or using an expert witness to rehabilitate the witness. It's often used to testify to current good character or reputation. Corroboration is bolstering the testimony of a witness by offering supporting evidence or testimony. This can be mandatory when one party to a crime testifies about the other. So when one party to a crime testifies about the other, that alone is insufficient to convict them. Some states require it in cases of false pretense, and it is rarely now required in cases of rape. If it's not mandatory, it is still often necessary to support the theory of the case. It's also not uncommon for witnesses to forget details. By the time they get to court and they're testifying, it's often far removed from when the event happened. They may be allowed to use materials to refresh their recollection. So they might be able to use a report that was made when their memory was fresh, that was made shortly after the event occurred. So past memory refresh is used if after review the witness now remembers details of the event. And past memory recorded is if after review they no longer remember, but they did create an accurate record when the event occurred. Past recollections recorded are considered hearsay and may be inadmissible. There are some exceptions that exist. Statement that would be admitted if made at trial today. Currently, the witness cannot accurately recall. The report was made when the memory was fresh and accurate. The witness can testify that the record was made, and the witness can testify that the report was accurate. Sometimes by the time you get to trial, a witness has died, has disappeared, or may be outside the jurisdiction of the court. Past statements from them may be admissible. Usually these need to have occurred under oath. In some cases, to ensure witnesses will testify, they might be held in custody as a material witness. Lay witnesses offer general testimony as what they perceive with their senses. So if you are a witness to a crime, you would be a lay witness. Most witnesses in court are lay witnesses. And this is generally under the opinion rule. The opinion of the witness is not admissible. Opinions based on everyday experiences are allowed. So this could be things like identifying the party, identifying their voice, how fast you thought something was going, what the emotional state of the party observed. So how did you feel at the time? Expert witnesses do not give an opinion on the ultimate issue as to whether or not perhaps a particular defendant is insane, but they would testify as to the type and degree of mental illness. This has traditionally been subject to the Frye standard from 1993, which is pretty similar. We'll talk about both of these cases. The Frye case concerned the admissibility of polygraph evidence, and the court established the rule that scientific evidence is admissible when it is generally accepted by the scientific community. So basically, this requires testimony of a number of experts to admit a new scientific test or process. And polygraphs remain inadmissible in court. So an expert witness, their testimony has to first be laid. First, there needs to be a foundation laid for their testimony. The expert has to explain the methods that they used and show how the methods apply. When laying the foundation, we have to determine, is the expert necessary? Is the area of expertise applicable to the current case? And does this particular witness qualify as an expert? Most modern tests must meet the Doe-Bear standard. Doe-Bear case concerned evidence of birth defects, and the Supreme Court stated that the federal rules of evidence had overturned the old Frye standard and granted judges wide discretion in admitting scientific evidence. So they basically become the gatekeepers of whether or not particular scientific evidence is considered admissible. It didn't radically change things, but it can require a separate hearing about scientific evidence and does set a standard. A series of questions, and then the judge will determine that indeed they're considered an expert witness. We often use hypothetical questions when we examine them, and we use that to show the probability of guilt or innocence. Testified to things like insanity, ballistics, blood and tissue, as to legal mental status. Insanity is a legal term, and so it is not for them to state whether or not someone is considered insane. They may offer testimony related to bullets or firearms, or show the relationship of blood, semen, or saliva to crime. And they also look at DNA evidence as well. And that wraps up the chapter on witnesses.